This employment law video is on disciplinary action. Unfair dismissal. Generally, employees who have at least 2 years continuous service with the employer are able to bring unfair dismissal claims. In misconduct cases, the dismissal will only be fair if the employer believed that the employee was guilty of the misconduct, had reasonable grounds for that belief, and carried out a reasonable investigation. The employer's decision to dismiss must also fall within the reasonable band of responses open to an employer. In performance cases, the fairness of the dismissal will depend on whether the employee had an opportunity to improve their performance and was given appropriate corrective action. The Acas Code. Employers need to be aware of Acas's, that's the Advisory, Conciliation and Arbitration Services Code of Practice on disciplinary and grievance procedures. Employment tribunals must take the Code of Practice into account in determining whether an employer acted reasonably or not. Also, if an employee wins an unfair dismissal claim, an employment tribunal can adjust an award up or down by 25% for an unreasonable failure to comply with any part of the code. Investigation. If invoking formal procedures is necessary, once the allegations have been outlined to the employee, a thorough investigation needs to take place. Acas has published a guide on carrying out workplace investigations. Where there is a serious misconduct allegation, it may be appropriate to suspend the employee pending the investigation. It's important to check that the right to suspend is set out in the employment contract. Usually, suspension would be on full pay. Disciplinary hearing. Should there be a case to answer, the employer will need to write to the employee, setting out the outcome of the investigation and inviting the employee to a disciplinary hearing. The employee should be provided with all relevant evidence and also the names of any witnesses. Where possible, the person conducting the disciplinary hearing should not be the same person as the person who is investigating the allegations. A person invited to a disciplinary hearing has a right to be accompanied by a fellow work colleague or a trade union representative. After the disciplinary hearing, the employee must be informed of the decision and their right to appeal. Appeal. Any appeal should be dealt with impartially and preferably not by a person who's been previously involved in the case. The person conducting the appeal should also be more senior than the person who made the original decision. Finally, remember that regardless of the employee's length of service, it's important to follow a fair process wherever possible. Employees can bring other claims such as for discrimination where there's no minimum length of service required, and employers will then be in a better position to defend themselves. That's my video on disciplinary action. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.